Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
I'm Mary Margaret Bush, Napa Legal's Executive Director. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. This week, we'll be covering the shocking conclusion of a multi-year case defending the freedom of Native Americans. We'll be looking at free speech claims from a sports apparel company and a victory for a Christian photographer in New York.
All right. Thank you, Mary Margaret. Let's dive right in. So this first one, this is an interesting time of the year, right, where the Supreme Court is handing down opinions. And this year in particular, there are a lot of Supreme Court opinions that religious liberty advocates are very interested in. Mary Margaret and I were just talking about this off camera before we started recording, but it'll be, I think, some exciting weeks ahead as we analyze these cases as they come out. This week, unfortunately, we have what is probably universally thought of as bad news for the religious liberty watchers. This is regarding the Apache Stronghold case that I think most people listening to this are probably familiar with. So I will be sparing on the details. I want to focus on one particular legal issue that will be left unanswered now that the Supreme Court has denied cert in the Apache Stronghold case. So as you all know, after fighting for several years, I think it was 2018 or so that this fight started in the courts to prevent the destruction of a site of worship. A coalition of Native Americans, right, appealed to the Supreme Court, who denied cert. When you're listening to this, it will have been last week. So the dispute dates back again to several years ago. There was a spending bill, a bigger, I think it was a defense spending bill. It was a must-pass bill, and there was a resolution contained in that bill transferring Oak Flat, which was the sacred site to the Apache Stronghold, to these Native American worship groups, transferred the control of the property from Apache Stronghold to a mining company that I believe was Chinese run, or at least partially Chinese run, that would effectively turn the land into a crater in the mining process. So it would have rendered the property unusable as a worship site. And that was the gist of the litigation. So again, denial of cert effectively ends this fight because once the mining arrangements are allowed to begin, it's likely going to be irrecoverable as a worship site. So now I think we're just kind of doing a post-mortem on what happens from here and what does this mean for the legal precedent going forward, because I think this is actually going to be the end of the fight for Oak Flat itself. So what I wanted to highlight here is, first, I want to point out we often take the text of RFRA, the Religious Freedom Restoration Act, for granted. It's basically in the wake of Employment Division versus Smith, where the Supreme Court held that the First Amendment does not really do anything for free exercise protection if the laws are neutral and generally applicable. So the Congress and then a bunch of states following suit passed a law saying strict scrutiny still applies if a neutral law is applied and in fact burdens religious liberty, right? So we know that it imposes compelling interest and narrowly tailored requirements like a strict scrutiny analysis in the court. But the statute is, there are 3 pages of it. It's not just a 1-paragraph strict scrutiny requirement. So one thing I wanted to point out, Congress's intent, the way I read it, is pretty clear and very broad, right? The purpose of RFRA, the first purpose listed in the statute, is to, quote, restore the compelling interest test and to guarantee its application in all cases where free exercise of religion is substantially burdened. Now, this is important because in all cases means in all cases, right? It means anytime that there's a law passed, in this case by the federal government, by Congress, that in fact substantially burdens religious exercise, RFRA is triggered, right? And you have this strict scrutiny requirement that the government has to meet. Now, I point that out because I want to focus on one specific issue in the current state of how RFRA is applied, especially after cert was denied here. And it's one that Justice Gorsuch spent much of his time reflecting on in his dissent from the denial of cert that just came out. So the Ninth Circuit in this case ruled that the transfer and then the subsequent destruction of Oak Flat doesn't constitute a substantial burden on the tribe's free exercise of religion, since there cannot be a substantial burden when the action in question involves the disposition of government real property. It's a strange precedent. I wasn't really familiar with it before diving into this dissent from the cert denial, but there's a long line of cases that makes it really, for some reason, RFRA can only be used very narrowly when you're talking about disposition of government real property. And Justice Gorsuch calls out the inconsistency and the problem with this. So I want to read at length here from Justice Gorsuch's dissent because I think it really frames the issue that I want to highlight. So I'm quoting from the opinion. He says, but thanks to Ling, which is a Supreme Court precedent from before Smith that we'll get to in a minute. Thanks to Ling, a different rule applies when it comes to the disposition of the government's real property. In that setting, the Ninth Circuit held, a substantial burden arises only when the government coerces people into defying their religious beliefs or discriminates between religions. And the Ninth Circuit reasoned, Apache Stronghold could not satisfy that standard because the government's plan does not force anyone to reject their religious beliefs and does not discriminate among religions. To be sure, the government's plan may promise the destruction of a sacred site and thus prevent religious exercises from occurring, but, the court reasoned, none of that is enough to amount to a substantial burden under RFRA when the disposition of federal land is involved, end quote. Now, I think Justice Gorsuch is right that cert probably should have been granted just on these grounds alone. This is a real problem, right? The idea that disposition of real property in general does not substantially burden religious exercise unless you're like forcing people to deny their faith. Justice Gorsuch says that's an extraordinary holding that easily merits this court's attention. I think he's right. So, as I pointed out before, reading the RFRA language itself, it's clearly broad in scope and it's clearly intended to cover all laws that substantially burden religious exercise. And to me, then, this is just a matter of simple logic, right? I don't mean to be flippant about Supreme Court precedent, but you can put precedent aside and just say, if it's meant to protect all instances where federal law or federal action substantially burdens religious exercise, here, there's a federal law, right? The transfer of this property from Apache Stronghold to a mining company that will clearly substantially burden religious exercise because these people exercise their religion on this sacred site. Now it's going to be turned into a big mining crater. To me, that's kind of the end of the analysis, and that RFRA should apply, right? The strict scrutiny analysis should apply here because I think the substantial burden is obvious, right? And Justice Gorsuch rightly points this out. He says, exactly nothing in the phrase substantial burden or anything else in RFRA's text hints that a different and more demanding standard applies when and only when the disposition of the government's property is at issue. And that's right. I think I haven't read all of Ling. I read through this line of cases a little bit to prepare for this, but there's just not good reasoning here. There's nothing in the text of RFRA that would say, well, when you're disposing of real property, there's a different burden. RFRA doesn't apply the same way. There's nothing in the text that says that. So it's troubling. I think the Supreme Court should have taken this case, besides for the basic reason that Apache Stronghold should have had their day in court over what I think is clearly a religious exercise burden, but also to resolve this problem of the way that real property dispositions are being treated differently under RFRA, because I think that's legally incorrect. So one other thing I would point out about Ling is that Ling was not interpreting RFRA. Ling is a pre-Smith case, so RFRA doesn't exist when Ling was decided. I think it was 1988 or 89. So when Ling sets different standards for real property, first of all, it's interpreting the free exercise clause pre-Smith, this is legally a little bit tricky. But Justice Gorsuch points this out as well, that while the purpose of RFRA was to basically restore the pre-Smith understanding of free exercise, right? And it refers to cases like Sherbert and Yoder, but Justice Gorsuch rightly points out that doesn't mean that we take all pre-Smith First Amendment jurisprudence and say, well, that's all that we do. That's all that we apply fully to RFRA. RFRA is a statute, right? So when we apply RFRA, we read RFRA and we apply it properly. This is not a RFRA precedent. So I think that's compelling. But then further, Justice Gorsuch points out that there were very different facts going on in Ling. The dispute there was whether the government building a road near a religious site that would generate significant noise and disruption, whether that violated the free exercise clause. So the court there stressed that the government's action would not substantially burden or, in fact, prohibit religious exercise, right? Now, I could see how you could get from one to the other and say, well, when you're disrupting real property, this isn't a substantial burden, but there's clearly a difference between building a road that's going to create noise next to a religious site and destroying the religious site, right? So even if you accept that Ling is controlling precedent and how we read RFRA, which I don't think it should be, even so, it's a different set of facts. And Justice Gorsuch points out pretty pithily that look for the analysis of what is a substantial burden in Ling, you won't find it. Like they're not really talking about what is or is not a substantial burden. It's a different case. Um, so I think there are real problems here. It's really disappointing, besides the outcome in Apache Stronghold, that the court isn't taking up this question because it does leave a really troubling ability for the government to, in fact, substantially burden, or in this case, entirely burden, like wholly burden religious exercise if it involves real property disposition. So I think that's a problem. And I was reflecting on this, and this will be for better legal analysts than me to kind of flesh out. But I think it's especially a troubling precedent given our rather broad and I think problematic takings clause, eminent domain jurisprudence after the Kelo case back in, what is that, 2008, where what the government has to do to take property for government use has been really broadened to be for government benefit, right? If you remember the Kelo case, they basically took the woman Kelo, they took her house and leveled it through eminent domain and used it to give it to a big pharmaceutical company as part of their campus. And like the public benefit had to do with like tax revenue and the public good. So to me, this makes it even more troubling because the government's taking ability is much stronger than like taking something to build a public road, right? If you're building an interstate highway, yeah, broader reason to be able to take private land. But if you can do it for anything that's technically a public benefit, then the government already has a lot of power to take private sites. And then if the current state of the law is that they can take religious sites pretty with a pretty heavy hand, and it's not going to violate RFRA or the First Amendment, I think we have a real problem here. I think we have a situation where like even historic worship sites are pretty broadly at the mercy of the government. Our good colleague Joseph Clement, who edits this podcast and who helps us write our weekly updates, had pointed out that like what about the Ebenezer Baptist Church, right, where Martin Luther King preached? Could the government find a public benefit and take it and then argue that, well, the Baptist community there, they're not being prevented from being Baptists, that we're not discriminating against religions. We're just taking this for a public use or a public benefit. It's a problem. It's a problem that RFRA doesn't properly apply here. And again, I'm disappointed to see that the court didn't take up this issue. So, Mary Margaret, I know I just said a lot here. I'd love to hear your thoughts on where we are after Apache Stronghold.
Well, I'll pick up where you left off on just expressing disappointment here on so many levels. I think, first of all, I was blindsided by this. It was very unexpected. I genuinely thought this could have been a 9-0 in favor of the Apache Nation. And I mean, if I had a Supreme Court fantasy league, I'd be absolutely in the drain right down the drain right now. This is not. I did not see this coming. And the pass on the decision was the outcome was disappointing, as you discussed. I think the pass on the decision was disappointing because this case had so many refreshing aspects. I think importantly, a lot of what the court grappled with are culture war issues. That we litigate those now. We don't really deliberate in other forums. We really litigate a lot of those. And this was refreshing because I reminded me of, I think I've said this before, but kind of a Y2K era First Amendment case where this was very purely complex legal issues. There were takings of elements, or at least, if not takings claims, there were certainly takings kind of aspects to this. This is a jurisprudential, deeply complex question that I think we would have benefited from seeing the court explore, particularly for the religious freedom aspects, but also for takings and interpretation in general. So it's very, very disappointing. The only aspect that didn't surprise me, but was that if there were two that dissented, that it would be Justice Gorsuch and Justice Thomas, because obviously Justice Thomas famously dissented in Kelo versus New London and is a great opponent of government oppression, and Justice Gorsuch is a famous advocate for Native American nations, and I've read multiple places that he's, of all the Supreme Court justices, most familiar with Native American tribal law, and um, he would have been able to bring some great insights to bear if this had actually been addressed or deliberated over. I think where we land is I prefer not to think of this as a setback. It's definitely a setback. In the interest of trying to comfort ourselves, I'm trying to think of it as leaving a lot of questions open. what we don't have here is we don't have clarity on the substantial burden aspect of RFRA still, and we needed that. We need that. Hopefully, the Mahmoud case will help a little bit with that, but it's an open issue, and I think I know in past episodes, you and I have talked about state RFRAs that are being drafted and what the best practices could be for state RFRAs. And after this case, I'm thinking, I guess we're going to have more robust definitions of substantial burden. And my instinct is initially not to do that. I think the founders rightly showed a lot of restraint because and in fact, some of them even were hesitant to include the Bill of Rights because they didn't want to imply that there weren't that our protections as citizens are limited. They are only limited as to the enumerated powers of the government. The Bill of Rights wasn't meant to be exhaustive. So I think as Americans, kind of our default should be that ambiguity should be determined, ambiguous things should be determined with deference towards protecting freedom. And so but that's not what's happening. And so I guess we need more specificity. I know you've looked a lot at state RFRAs and best practices. Is that your take, or do you think there's riskiness if we start getting more specific in RFRA language, Frank?
I have a hard time with this because I think in the end, when you see decisions like this, that you're probably right, that some specificity might help. But to me, and I don't want to sound flippant or cynical here, but maybe I feel a little bit cynical after this, that like, what do you do, right? You have a definition section that says substantial burden means substantial and includes total, or all laws means what? Would you define all as all, including real property laws? I don't know. I think you're right. There needs to be some serious thought about what you do to make sure that these are encompassed. But to me, just the text of RFRA as it is should be pretty clearly sufficient to address these types of cases. So I think you're right, but I think it's unfortunate that you're right, frankly.
One of those things where you don't want to be right, but here we are. So, relatedly, on the subject of state legislation, there is an infamous, somewhat Orwellian titled law in Colorado that has been called the anti-discrimination law, although it departs very, very significantly from anti-discrimination principles, in my view. So this law, it's a bit notorious. It was the one, if I'm not mistaken, I believe this was the one under which Jack Phillips's freedom was challenged in 303 Creative. Is that correct, Frank? Do you recall specifically if those were the challenged laws in those cases?
Yeah, is it called CADA, right? Colorado?
Yes.
Yes, that's the
Yeah.
infamous one. That's right.
So, riffing off our traditional CADA challenging First Amendment freedoms, um, XXXY Athletics is an apparel company in Colorado, and they were formed to promote and protect women's participation in sports. And obviously, there's a lot of concern around that lately because when men who choose to identify as women are participating in women's sports, there's, among other things, significant physical asymmetry. And so there's a lot of physical harm that occurs to women, or even a chilling effect where they're not able to play hard because they could get, as one person depicted in an XXXY ad, was neurological damage and partial paralysis after um, a man spiked a volleyball into her head, sadly. Um, I believe it was unintentional, to be clear, as far as I can tell. But the damage was remarkable and life changing for this young woman. And so XXXY is trying to draw attention to this and confront head on the issues around women's sports and the risks of transgender issues sort of being weaponized in the women's sports context. So this is kind of a cool case that the First Amendment rights that XXXY is invoking is our speech, press, and assembly. So we've seen freedom of speech before in 303 Creative. This is an expressive activity. They're creating these products. They're telling a story around those products. I'm excited and curious to see the press and assembly. So the press is coming in because this company's advertising their products while also telling these stories. And their freedom of assembly is that they're bringing together groups and coalitions around the story and the concerns that they have and that they think need to be part of the public debate on these issues. I'll bring that all to bear through their kind of strategic plan. So Colorado, yeah, not gonna say anything snide or throw shade in Colorado, but the temptation is certainly there. Colorado is trying to make this speech illegal. They now are they've amended this so-called Anti-Discrimination Act. We'll just call it CADA to avoid making it sound better than it is. They've amended CADA to include chosen name and chosen term of address as protected classes. And so then anyone who doesn't um, get with the program on someone's chosen name and how an individual chooses to be addressed can be prosecuted under CADA. So um, so here we are again. ADF, thank you, ADF, is coming to the defense of this athletics company, pointing out the gross First Amendment violations involved here. I almost feel like I don't need to say why this violates the First Amendment or get deeply into the problems here because they're so self-evident. And I want to focus a little bit more on just some of the deeper aspects of why this is so troubling. What I read recently, a piece that was talking about, you know, the spirit of the age, which is um is kind of a modernist concept, but there's certainly value in that phrase. And they say that spirit of the age kind of reflects the values, this premise. I don't know if I agree with the premise, but what I do think is to the extent that our era values therapeutic comfort over truth and rigorous search for truth, that certainly seems like what's playing out here. And if you haven't read any Carl Trueman, I highly recommend reading him because he's very good at interpreting the underlying kind of uh, the underlying problems that are leading to symptoms like this attempt in Colorado. It also reminded me a lot of kind of the Solzhenitsyn's worldview. I think there's almost nothing more disturbing than when people try to use power to force the settlement of critical issues related to the common good, not by argument, not by engagement, but by quashing debate through law. Um, and Solzhenitsyn, I wanted to bring in a particular quote from his. He talked about in his Harvard address how his concern with Western society was that the defense of individual rights has reached such extremes as to make society as a whole defenseless against certain bad actors or ideologies. And again, here we are with this athletics company um, saying a message that in my mind isn't even controversial. I'm not even appealing to sense of truth, morality, theology, just saying, look, you don't have to agree on any of those fundamentals. Let's just look at the results. The clinical studies on the approaches here are really at a minimum suggestive that physical interventions in this kind of reorganization with men and women's sports is harmful. The At a minimum, the jury is out, and I don't even personally, I don't think the jury is out. I think there are conclusive studies that show this is not good, in addition to being flawed as a matter of principle. And Solzhenitsyn, on the same kind of line of thought, also writes that this kind of oppressive lawmaking prevents the most independent-minded person from contributing to the public life and ends up giving rise to herd instincts that block any kind of successful development toward the common good. And so he said it best, and that those are really the things that came to my mind here. It's like Colorado is harming its own chance of ever becoming the place that I think at some level they want to be. I mean, if you call a law not undiscrimination law, hopefully you're trying to promote flourishing, but they couldn't be going about it in a way that's any worse, really. So, Frank, you looked at this state law multiple times and similar state laws, not only in this case, but in one we'll discuss just shortly. What's your take here?
There's so much to say, and in the interest of time, because you covered this really, really well, just a couple of notes. For one, I actually like seeing things like this because I think they really point to the aggressive, coercive nature of what's going on here, right? There are subtle laws that try to chip away at freedom of religion or other freedoms that are harder to fight with, harder to argue against. But these are heartening to me because right when you add into an anti-discrimination statute, right, with this new amendment, chosen name, how an individual chooses to be addressed, what you're saying is that people have to speak in a certain way, right? They have to address people in a certain way, or else they're violating non-discrimination laws. This is so blatantly viewpoint-based speech discrimination that I think this gets shut down by this First Amendment challenge like pretty quickly. Same thing with like the Washington clergy penitent exemption that we discussed recently, right? Where it's like all professional privileged communications are exempt from mandated reporter status, right? Nurses and their patients, therapists and their patients, all except members of the clergy. Like, yes, I like these blatantly unconstitutional statutes because they really, for one, they don't hide the discriminatory intent of the legislatures that are passing them. And I think it's good to have those things out in the open. And two, they get struck down because they're blatantly unconstitutional. I don't think they're hard cases. So I'm almost grateful that Colorado is being so brazen. But the other point that I want to make is playing off what you said here about debating these things in the public square. It's important that unsettled issues be part of the public conversation instead of attempting to suppress them from on high. And the reality is those kind of suppressions using law to shut down debate on legitimate issues, it doesn't work, right? Like we've seen this several times, I think, in the past 60 years or so in this country, right? That Roe v. Wade and then Planned Parenthood v. Casey tried to shut down the debate and say, no, abortion is a constitutional right. It might be hotly disputed, but we're not allowing the dispute, right? It didn't work, right? From the moment Roe was decided in 1973, the pro-life movement just grew and grew and grew until we got Dobbs and the end of that almost 50-year legal regime. More recently, there's a really good article. I don't know if you saw it, Mary Margaret, from Matthew Schmidt at First Things a couple weeks ago called "How Obergefell Failed," and he's making a similar point that, like, a decade ago there was this hot argument about whether same-sex couples can be married. The court shut it down and said they have a constitutional right. We're not allowed to debate this. That's the end. And what Matthew Schmidt points out in this article is that it was announced as like this humane. The New York Times called it the Supreme Court's decision in Obergefell one of humane grandeur, and remarked on the dwindling number of Americans who oppose same-sex marriage. And Schmidt says the trend is reversing. The number of people who reject same-sex marriage is on the rise. And you see this pretty much anywhere, even like the shutting down of right-wing parties in Europe, right? That when you try to suppress them, they grow because you can't suppress things that the people actually have real disputes about, legitimate disputes about. And so this doesn't tend to work. I don't mean to go on and on here, but I think it's important that, like, for one, it's blatantly unconstitutional under the First Amendment to say that people can't speak this way or else it's discriminatory speech and they're violating the law. You just can't do that in America. But also it doesn't work that when you take, like you said, very real issues, especially here with physical asymmetry and just the biological difference between men and women, and you say that doesn't exist, you're not going to get rid of that common sense observation in the people by saying legally they have to stop talking about it. All right. Well, I guess we're not going to stay in Colorado, but we'll have echoes of Colorado as we discuss our last issue here, right? So this is a really interesting case that we'll wrap up with here. And this was in New York State. A photographer named Emily Carpenter has run a professional wedding photography company since 2019. This will probably sound like a familiar fact pattern here. Carpenter is a Christian. She believes that marriage is between one man and one woman, that marriage is a gift from God. And so she limits her wedding photography customers to opposite sex couples. New York has a public accommodations law. Sounds like CADA, right? Would require her to photograph same-sex ceremonies if she's in the business of wedding photography at all. If you're remembering Jack Phillips, the cake baker, or Laurie Smith, the wedding website designer, that's for good reason. This is very much in that same line of cases. So in this case, Emily Carpenter sued the state of New York. This was pre 303 Creative, so we didn't have a Supreme Court ruling on this exact issue at that point. And the trial court initially ruled against Carpenter. This was in 2021. It was appealed. Since then, the Supreme Court ruled in 303 Creative. And so Emily Carpenter's appeal was remanded, went back to the trial court, and now post 303 Creative, she prevailed in the same court that initially dismissed her case. So the court's ruling here states that 303 Creative institutes this two-part test for cases like hers. First, the plaintiff, so here Carpenter, has to prove that the law that he or she is challenging would compel her to perform an activity she otherwise would not engage in. Here, that's clear, right? She would not photograph a same-sex ceremony if the law didn't try to compel her to do so. So she meets prong one. Second, the plaintiff has to prove that the activity in question is her expressive activity, right? So if you remember, 303 Creative was not decided as a free exercise of religion case. It was an expressive, I think it was a speech case, right? So there's been a lot of this, seeing cases that have a religious belief element to them litigated as freedom of expression, freedom of association, freedom of speech, rather than free exercise. There are strategic reasons to do that. But here it creates the interesting second question, right? If you're just selling a product, right? If you sell batteries or whatever from your store, it's not expressive activity, probably, right? But if you are engaged in expressive activity, then it falls under the First Amendment, right? You have free speech rights. You have the ability to express the opinions and the activities in the way that you feel compelled to, and not in any way that the government says. So the line here is what's expressive activity and what's not. And it's an important one that we're going to see, I think, more cases like Emily Carpenter, is to kind of figure out the parameters of what counts as expressive activity in the wake of 303 Creative, right? So in Carpenter's case, her photography is customized. It involves her own creative judgment and decisions, involves her own style, right? Photography is an art form. It's not a product. You don't just like set up a camera in one corner, press a button, shoot, print, send out the pictures. It's not just the like factory production of a product. There's an artistic expressive activity going on here. That's what the trial court in New York found. And so her photography business for weddings is legally an expressive activity. And so the court here ruled that the First Amendment, in light of 303 Creative, protects her right to conduct her business in alignment with her faith and to only engage in that wedding photography for couples that involve one man and one woman. So I think it's an important development, and it's important that we highlight these things as they happen at the trial court, right? When the Supreme Court sets a precedent protecting religious liberty or expressive liberty activities, these are crucial, but these precedents are not the end of the fight. In a way, they're the beginning of the fight, right? Because the Supreme Court doesn't just give you broad philosophical principles and say, anytime anybody's doing anything like this, it's protected by the First Amendment. That's not the way that our court works, right? There has to be an actual case or controversy with specific facts that are being litigated. And when the court makes its decision, it's contingent on the facts, right? In 303 Creative, it said, well, Lori Smith designs wedding websites. Those are sufficiently an expressive activity that it falls under the First Amendment. So you have a precedent, but the precedent has to be fleshed out with different cases, right? What's an expressive activity? We know that a wedding website designer who makes custom websites is an expressive activity, but we didn't know at the time 303 Creative was decided, how would this apply to different groups, right? Are florists just selling a flower, or are they expressively creating an original product through their arrangements? Are photographers merely pointing, clicking, and selling photographs as a product, or are they providing an expressive service? We don't really know these until each of these fact patterns gets litigated. So hats off to Emily Carpenter for engaging in a needed fight to protect her livelihood, but also to continue to push this forward. And I think we're going to see more of these. This is an encouraging outcome, but I think there's going to be an ongoing fight as courts define the contours of what counts as expressive activity and falls under these First Amendment protections.
That's such a good overview, Frank. I'm gonna underscore what you just said about just hats off to Emily, as well as I think you made a really, really important point about the Supreme Court victories are the beginning, not the end. So 303 Creative was decided in 2022. This litigation started in 2021. So Emily stepped forward a little bit in faith. There wasn't any guarantee this was going to be successful. And like you said, when the victory takes place, when there is this kind of clarity around the First Amendment freedom, that's when the work starts. Because great outcome for that plaintiff, the similarly situated people around the country have to go through do the work um, to also make sure that their First Amendment protections are not being abridged. I'd of course be remiss not to note that this is a Section 1983 claim. Emily's suing Letitia James for violations of Emily's constitutional rights. So love our Section 1983 claims. And I think I hope we'll see a similar outcome soon in the Colorado case. I think this is, as we said, a similar fact pattern to what we're seeing with the XXXY decision. And yeah, I think and it's an encouraging note to end on here. So I think we have a lot of important themes coming up. First Amendment freedom is kind of traveling in a pack these days, and the importance of doing the work to get the religious freedom protections. I also wanted just to kind of put a fine point on it. I found the district courts, I think it was a district court, but I found the court's decision in favor of Emily, her request for a preliminary injunction, which basically means don't do this, stop, freeze. It was particularly striking. So I wanted to paraphrase what the court said. It says, for the foregoing reasons, Emily's motion is granted. Defendants, so the state of New York, Letitia James, those in active concert with them, are enjoined from the following. And it's forcing the plaintiffs to offer these services, preventing, this is insane, uh, forced from for, prevented from forcing the plaintiffs to adopt the state's desired beliefs and practices policy. Unreal. Forced prevented from forcing the plaintiffs from asking questions to determine what types of services they're seeking, and enjoined from preventing the plaintiffs from posting their desired belief statement on their website. Like, this is definitely a victory, but then when you read that grant, you're like, hey, thanks for not forcing me to adopt your beliefs and not stay my own. I mean, great that she won, but also kind of, was that not a given? I mean, it's almost humorous.
There's a pun to be made here about a 1983 claim in a 1984 kind of situation where it's yeah, and joining the government from forcing this woman to think a bunch of things about a really contested issues is like, it's surreal that we have a court having to enjoin so specifically about thought policing, but it's also encouraging to see such a specific ruling, right? To say, like, to be clear, the state of New York can't do XYZ. I'm grateful for it, just so there's not a lot of ambiguity about what the state can't just continue to do going forward.
Yes, what a week. Well, thank you all for joining us for this episode of the Napa Legal Podcast. If you enjoy our content, we would appreciate it if you would like, subscribe, and follow our channel on YouTube, Spotify, or wherever you listen. We hope you'll join us again next week as we continue to highlight and discuss some of the most important ongoing legal issues affecting religious liberty and the work of faith based nonprofits.
We'll talk to you all next week. Thank you so much for joining us, and God bless you.